Oh yay, oh yay, oh yay. The Court of Appeals for the 4th Judicial Appellate District is now open pursuant to call.
Good morning, everyone, and welcome to the 4th Court of Appeals. At this time, the current environment precludes us from holding live arguments in our courtroom at the Cadena Reeves Justice Center in downtown San Antonio. The court welcomes the advocates on this Zoom virtual platform, as well as the interested parties and the general public on our YouTube channel. Please be aware that should we suffer any unforeseen technical difficulties, I will stop the clock. If necessary, I may temporarily suspend the proceedings and the judges will recess briefly. Our clerk of the court, Mr. Michael Cruz, will provide you with further instructions and assistance as needed. Once resolved, I will resume the hearing and counsel will proceed for the time that remains allotted to her or him. As you know, on May 8th, the Office of Court Administration, the IT provider for the state appellate courts and state judicial agencies, suffered a ransomware attack that affected all state court websites and case management systems. Please be assured, however, that this panel has the complete briefing and appellate record and is fully prepared to submit the case and to issue a judgment and opinion accordingly. In light of the virtual nature of these proceedings, I wish to provide you some guidance to help you navigate through the panel's questions this morning. The justices have decided to raise their hand like so when she wishes to ask a question. I may have to verbally interrupt you should your attention veer away too long from the screen. At this time, beginning with counsel for appellants, I call for announcements in cause number 0419 00288 CV, DCP Sandhills Pipeline LLC versus San Miguel Electric Cooperative, Inc.
Good morning. Tom Zabel on behalf of DCP Sandhills.
Morning.
Morning.
Good morning. Melanie Fry for the Appellee, San Miguel Electric Cooperative, Inc., and we're ready.
Very good. As you know, you each have 20 minutes respectively to make your arguments, and appellant will have 10 minutes for rebuttal. Counsel, you may proceed.
Thank you. May it please the court. I'd also like to thank the court on behalf of all counsel for allowing us to have oral argument during these difficult times. I would like to jump right into my oral argument and start with the prior public use doctrine. I think that's the easiest issue for the Court of Appeals, and I think the issue that the most easily dictates reversal in this case. It was San Miguel's or SMEC's burden to establish the application of the public paramount use doctrine. It's very difficult and not applied very often and very difficult to prove. They fail to prove it in 3 different respects. The first is it has to be a public use. And they're saying that lignite mining is a public use. Lignite mining has never been a public use in Texas and never will be, because the legislature, I don't think, will ever declare strip mining of lignite or any mineral to be a public use. I'm not aware of any statute that has ever been enacted in the state of Texas that allows to condemn a mineral, coal, lignite, oil, or gas. Texas has always encouraged it to be privately developed. And it would come as a shock to the entire oil and gas industry and mineral owners to know that someone could condemn their natural gas, coal, or lignite. Because I will say natural gas burns much more in the electric generation plants than lignite does. If they can condemn lignite, they can condemn natural gas. So they have not proved that it is, in fact, a public use. On that, if you look at the statute, and it's called the Electric Cooperative Corporation Act, the ECCA, and it talks about rural electrification. And most importantly, if you look at section 161.112 of that statute, it talks about what they can do. They can acquire, own, hold, maintain plants, buildings, works, machinery, supplies, equipment, apparatus, and transmission and distribution lines. And they can generate, acquire, and accumulate electric energy for sale and transmission. There is not a word mentioned anywhere about them mining or going out and drilling oil or gas wells or condemning lignite, coal, or natural gas to carry out their functions. The statute talks about them generating it and transmitting it, not actually acquiring the natural gas or the lignite or coal that's going to fire their plant. So we would submit that it's very clear that there is not a public use, and the case law is that you have to have the power of eminent domain for this doctrine to even apply. They're not a public use. They don't have the power of eminent domain for lignite mining. They do have it for generating and transmitting electricity, for condemning a power plant or condemning power lines. So that's the first point. The second point is that they don't have a pre-existing use. When DCP came along in 2012 and put in their pipeline, while it was under lignite lease since 1954, there had been no lignite mining on that property. In fact, they couldn't lignite mine because the Railroad Commission hadn't granted them a permit. They hadn't even applied for a permit in 2012 when we put in the pipeline. And yes, ma'am.
Unmute, pardon. Counsel, what authority would you rely on to have us define the term existing?
I would rely on the Canyon decision. It's the most recent decision on the issue. And that's a Supreme Court decision in 2008. And while they talk about, being devoted to a public use, what they mean, they explain what they mean when they say devoted. It has to be an existing use. They use the terminology existing use. And they go all the way back to refer to the Sabine case, which was decided in 1898. And in the Sabine case, you basically had a railroad track company trying to put a railroad over another person's railroad yard, which was in existence. And they also talked about interfering with an existing use. In the Canyon case, it's very interesting. You had a river authority, you had a lake that was used for recreation and other purposes. And a water district wanted to put a water intake in the lake itself in a pipeline. And the river authority said, no, you're going to interfere with our lake and recreation. It's going to be a hazard. Boats are going to strike it. And basically the Supreme Court said, they looked at and said, you have to substantially destroy or render almost meaningless the existing use, which was for recreation and use by the river authority of the lake. And what they did in that case, which is also very important, is they said you don't look at just part of the facility that's being interfered with, in this case, the lake. You look at the entire property, the 400 or 500 acres of the lake, not just the part that's impacted by the water line. And they said that basically it only affected 0.5% of the entire lake. In our case, we have a 12-acre easement on a 2,200 acre tract of land, 0.5%. We have a 0.5% impact on the entire property, much like they did in the Canyon case. Then there's also the Laird Hill case, which is an interesting case, also talking about existing use. In that case, you had a company that had drilled a saltwater disposal well, and their lease terminated, on which they drilled the well. Some other entity comes in and gets the lease and takes over their well. And then the first party who put it in condemns it. And they basically, the court looked at that and said, well, the existing use was actually the well itself, in that the first owner, the one who drilled it, had the prior use, actual use. In our case, we put our pipeline in 2012. Our pipeline was in place for almost 6 years before they started mining lignite. They filed their application in 2014 with the Railroad Commission. It had deficiencies and they didn't really push on it until 2017. And they got their permit in 2018 and started mining in 2019. Yes, Justice Martinez?
Question. To the extent that it may or may not preclude summary judgment, in my first question, and in my second question, whether or not this is a limited circumstance where need our court say that this type of use is a public use in all cases. Specifically for my first question, the fact that the land was already covered by an lignite lease, would that make this a limited circumstance? And again, whether or not the evidence submitted by San Miguel regarding the significant expenditures it made to survey, drill all of the archaeological and environmental evidence submitted by San Miguel, does that preclude summary judgment, at least on that issue about existing use? And again, can this be simply a limited circumstance where this court need not say that in all cases, lignite drilling is a public use?
I don't think that it's limited. This case causes a limitation. The preliminary things that San Miguel claims they did, drilling for cores and doing some exploration and surveying, none of that was interfered with by our pipeline. I mean, this is a no-term lease. They may not mine lignite for 300 years or 200 years. And so what the courts are saying is, and we've cited, there's not a lot of great Texas cases on this. The Snellen case is the only one we could find that basically said, you have property that you've held for public use, but you haven't used it to its full extent. That was a case where you had an esplanade for a city road and they wanted to put a firehouse right there on the esplanade. And the court looked and said, you've had this for 50 years and you haven't done anything with the esplanade. Yes, you have a road on both sides, but the firehouse doesn't interfere with it, with your existing use. So they can't sit there and just hold it for 100 years or 200 years and basically say, no, but we're going to come on and mine maybe at some point in the future. That's why courts say existing use. And we cited the court, and I'm saying the Snellen case is the best case we have, but we cited the court to a lot of out-of-state cases. And there's a case in the Supreme Court of I believe it's Alabama, about 1913, where they said across the country, every jurisdiction in the United States requires an actual use, not a proposed use, not something you may do in the future. You have to have that use at the time that the test is applied. And in this case, the test would be applied either when we put the pipeline in 2012 or when we set security on our condemnation bond in 2017, where we posted the money and took possession under our condemnation cross bill. So I don't think this would be an exception to that rule. I think if you follow the Snellen case, the fact that they've just had it all this time, but weren't doing any actual lignite mining at the time would not exclude this from the rest of the line of cases. Yes, Justice Watkins.
Good morning. So the policy behind this doctrine, right, is that you don't want anything to happen that would interfere with the public's ability to use this property. But I can kind of see to the argument that was raised in Ms. Fry's briefing that this is a multi-year process, and that does make it existing. That all of the preparations are required to make this a use that does benefit the public. Can you speak specifically to that?
Sure, and of course they didn't really do anything that was visible to anyone until 2014 when they filed their application with the Railroad Commission. I think it's undisputed in this case, they can't do a thing. They cannot mine lignite, start the lignite mining process till they get a permit approved by the commission, which they didn't get until 2018. So I think it really is how far, whether this court wants to require an actual existing use or a proposed future existing use. I think all the case law, if you look, and we've cited multiple railroad cases, every single case that has applied the public use doctrine or paramount public use doctrine in Texas has involved an existing physically situated asset, railroads, roads, the Lake Dunlap in the Canyon case, the rail yard in the Sabine case. There hasn't been a case that I'm aware of. I'm sorry. Was there a question?
Mr. Zabel, I do have a question. We know that whether something is a public use is a question of law. tell us, do you think whether something is existing, an existing public use, is a question of fact? Now, we know that the Supreme Court has told us that there's no hard and fast rule about when something is a public use, and we've got to take it case by case. But tell me about whether a public use is existing is a question of fact or a question of law.
I would say it's a question of law. I mean, I think everything that I've seen in the elements of the paramount public use doctrine are all questions of law, including whether there's a substantial destruction or practical destruction of the prior use. I think every one of the issues in the paramount public use doctrine is a legal doctrine that it's all decided as a matter of law. I'm going to move on to the third element of the paramount public use and then move on to a couple other arguments. I think the thing that really is even stronger than my first 2 points on the paramount public use is they have to show it practically destroys their lignite mining. They were able to lignite mine. They were lignite mining, started it in 19, and they're pretty far on the way. I don't know if they've finished on the Wheeler Ranch, but they've been lignite mining since 19. And it has to substantially or practically destroy their entire lignite mining operation for this to apply and to shift the burden back to me. So what you have in the record is they originally claimed that 550,000 tons would be sterilized by our pipeline out of about 9.75 million. That's 7.6% of the lignite they were going to mine in their new area. This Railroad Commission sworn testimony, they said they'd lose 356,000 tons out of the 9.75 million, or 3.6% of their lignite reserves. And then at trial, when we tried the case on the isolated issues, they said 743,000 tons, which would be 14.6%. Even if you take their highest percentage of sterilized lignite, 14.6% is not practical destruction. What they could have done, which they chose not to do, is we had a condemnation claim. They could have gone for compensation on what we sterilized and got paid for that. They chose not to do that. They chose to put their eggs in the basket of, you have no right to condemn because of the paramount public use doctrine, and they took the risk of that and the fact they may not get compensated because they killed our condemnation case. So we would say there is no way they can prove that there is a practical destruction, because they're going to end up mining 90% or more of the lignite that's in their area. I'm going to move on to the next issue, which is the declaratory judgment versus trespass to try title. I'm sorry.
Before you move on to that, Mr. Zabel, I was wondering if you could talk, let's just say the court agrees with you and there was a fact question that precluded summary judgment. What does our judgment look like to remand the case, since the pipeline has now been moved and your only live claim in your pleadings was for condemnation?
They have I think the paramount public use is decided as a matter of law. So either they proved it as a matter of law or they didn't. And we say for all three reasons they didn't. So I believe if the court determines they did not establish the paramount public use doctrine, then they got a wrongful injunction, send it back and we'll go against their security. That's why we had them post the security. We tried to supersede this so that we wouldn't have to move our pipeline. They came in and said, no, we want you to remove your pipeline. We'll post $7 million to secure you. You go move your pipeline. And if we're wrong, you come against our security. So that's what we would ask, is if you find that they haven't satisfied it as a matter of law, render the judgment in our favor, and we'll go back and prove up our damages to the trial court and draw against their credit that they posted to secure us against that.
And as a follow-up question, would that be a measure of damages for your condemnation claim? It seemed to me that your condemnation claim only was essentially for specific performance, to not have to move the pipeline. But since you have moved the pipeline, help me understand how that claim is still live.
So that claim is much like there's another case, which I'll get to in a minute, but there was a case where someone filed a condemnation, it got dismissed, and they filed a second condemnation. And then they said the second condemnation made the appeal of the dismissal on the first condemnation moot. And the court said no, because there's damages involved. And what we have is a wrongful injunction. The remedy on a wrongful injunction is drawing against the security. They have a wrongful injunction that they got because they erroneously got the trial court to find that there was a paramount public use and we couldn't condemn. We're not going to go back and condemn. We're going to go back and we're going to draw against their security and show the damage we suffered by a wrongful injunction. I hope I answered your question. On the trespass to try title, this is really simple. There's a lot, I know you've probably read the cases. There's a lot of cases. You guys have, I'm sorry, the San Antonio Court of Appeals has issued a couple of decisions on the trespass to try title versus declaratory judgment. And those cases, you've got the Mellon Brunch case and the China Grove case, where the San Antonio Court of Appeals has said that when superior title is an issue, or where you have a case where you have competing instruments, then you have a trespass to try title case. And those two cases, I think one's in 2018, one's 2011. And more importantly, the Supreme Court of Texas, in a recent decision, said, and that's in the, find it, here it is, the Lance versus Robinson, 2017, that if you have a superior title issue, that someone's claiming superior title, and they look at what the plaintiff is claiming, and if you read the opinion, they put that in italics in the appellate opinion when they wrote it. Look at what the plaintiff is seeking. If they say that they have superior title against another instrument, and they're trying to knock out another instrument, it is a trespass to try title case, end of story. And in their pleadings, here's what they say. They say that they ask for a judgment in their pleadings that the duly recorded lignite lease is first in line, first in right, and therefore superior to the Wheeler easement. The Wheeler easement is invalid and void to the extent it interferes with San Miguel's lignite lease rights, and that it has the superior right to DCP's right. That is a classic trespass to try title scenario. It has to be done as a trespass to try title case. And all the case law indicates that in a very strong way. I'm down to 50 seconds. I do talk fast, so I might be able to get a little bit of my other argument in. The validity of the lease. Here's what's different. When you have a trespass to try title case and you have a lease, they have a lignite lease, which is a fee simple determinable. It's not a deed. If you have a deed, all you have to do is show your chain of title to the sovereignty or the common source, and you satisfied your prima facie burden on trespass to try title as a plaintiff. But when you have a lease, and we've cited the cases in our briefing, you have to make a prima facie case your lease is valid. Otherwise, you have nothing. So in all these no-term cases, and in fact, the cases that they cited in the Wheeler case, which was argued yesterday, the no-term cases that when they were contested on those that they cited, they proved the payment of rentals all the way back to the inception of the lease. And here they only did it to 1978. And when a lease terminates, it vaporizes. There's nothing that can be done to restore it unless you sign a reviver. I'm sorry, I'm out of time, so I don't want to violate the court's timing.
Very good. You'll have 10 minutes for rebuttal, counsel.
Thank you very much.
Thank you. Ms. Fry.
May it please the court, Melanie Fry for the Appellee San Miguel Electric Cooperative, Inc. I want to start my argument where opposing counsel started with the paramount importance doctrine. I think it's important to back up and look at what this doctrine actually requires according to the case law. The paramount importance test is a long-standing test we have here in Texas. It prevents a party from condemning property when the property is already devoted to another public use and the condemnation would practically destroy or materially interfere with the use to which it was devoted. If you can show that, then the party that wants to condemn can't go forward with the condemnation unless they can show that their purpose is of paramount importance and cannot be practically accomplished in any other way. There's no dispute in this case that DCP cannot satisfy that final element. Of course, this could be done in another way. The uncontroverted evidence put before the trial court was that this could have been located in another place. In fact, the pipeline was eventually moved. That's not an issue. The fight here on appeal is whether the trial court was correct in holding that DCP's pipeline materially interfered with San Miguel's existing public use. And starting with the existing public use, it's important to remember that the Texas Supreme Court has told us that Texas courts liberally view what constitutes a public use. It is not a difficult test to prove, as counsel for DCP just suggested. Instead, the Texas Supreme Court has told Texas courts liberally view what constitutes a public use. San Miguel's lease is unquestionably dedicated to a public use at the time that DCP moved to condemn. San Miguel is a not-for-profit, it's an electric cooperative. It's formed under a Texas statute, the ECCA, that exists solely and exclusively to engage in rural electrification by mining lignite for generating electricity for public use. And the facts about what San Miguel is and what it does and the existence of this lease, as you noted, Justice Martinez, these are important because in this appeal, DCP tries to make a meaningless distinction between rural electrification and mining lignite for rural electrification. Yes, Your Honor.
Yes, my question I was anticipating to ask you, it appears that DCP concedes, the evidence that shows San Miguel was using this land for strip mining purposes, but again, attempts to bifurcate that activity and say that, and it argues that strip mining is not a public use. So according to your opposing counsel, there's a distinction between generating electricity in a power plant and actually strip mining the fuel source for that plant. So by categorizing each activity separately, it essentially says that the fact that strip mining is the means to extract a fuel source, as it does for most of South Texas, to generate electricity is essentially irrelevant. How do you respond?
My response is that the arbitrary distinction DCP is trying to make completely ignores the actual facts of this situation. San Miguel's power plant is specifically engineered to consume the precise and unique kind and quality of lignite right here in this mine. The lignite underlying the leases in McMullen and Atascosa counties is San Miguel's only source of fuel. San Miguel is the sole generation only electric co-op in Texas. What does that mean? That means that San Miguel's function is to mine lignite and generate electricity. And it is the sole generation only electric co-op in the entire state. San Miguel is not involved in the distribution part. This is their job, to mine lignite, and this plant was created to mine this specific kind of lignite. So its sole function is to mine lignite for supplying the power plant that generates electricity. And as Your Honor pointed out, there's a lease here. There's a valid lease to mine this lignite. This is not, we're not talking about the power of eminent domain of condemnation. I think that's crucial. I want to clear that up for the court because counsel for DCP told this court that the right of eminent domain, the right to condemn these minerals, is essential for the application of the test, and that is not so. And I point Your Honors to a point in DCP's reply brief where they say, look, San Miguel does not have the right to condemn this property for lignite mining, and therefore, if they don't have the right to condemn, this test doesn't apply. And they cite the court to 4 cases. They're all out of state, 1 South Carolina, 2 New Jersey, 1 New York. And they quote from these cases and say, see, you have to have the right to condemn. It is incredibly misleading to this court. Those cases are applying a different doctrine called the prior public use doctrine, not Texas's paramount importance doctrine at issue in this case. In those out-of-state cases, they're dealing with 2 entities that both have the power to condemn. So you can imagine you get in an endless gridlock, like I condemn you, well, I condemn you back, well, I condemn you back. And when that's the situation, they have to develop a test to figure that out, right? About who gets to condemn. And so the statements in DCP's brief are cherry-picked from that scenario. That is not the law in Texas. The law in Texas of paramount importance doctrine looks at not whether San Miguel had the authority for eminent domain to condemn lignite. That's not the inquiry. In Texas, the inquiry is, did San Miguel have a existing public purpose? Of course it did. Of course it did. We've seen that in the statute that DCP's counsel referenced. We see it in yes, Your Honor.
Need we hold that strip mining in all cases is a public use?
Absolutely not, Your Honor. I think, in fact, that the inquiry is not, is mining lignite the public use. The public use for San Miguel is rural electrification. And the only way they do that is to mine lignite pursuant to the lease that's already in place. The way they do that is pursuant to the power plant already built, already constructed, that uses the feed specifically from this place. And so that's the analysis that should control here. As far as, yes,
Ms. Fry, so are you saying that because there's a lease and there's a plant, a power plant, that the sourcing of the lignite to fuel the co-op is public use? I mean, do we need all of those things for it to be public use, or can you just clarify that for me?
I think that all of those things prove that San Miguel has a public use. I think when you look at what the statute allows this electric co-op to do, when you look at San Miguel's certificate of incorporation, its articles of incorporation, and they say, you know, our purpose is to engage in rural electrification by any one or more of the following methods. And the second one listed is to obtain and furnish the necessary fuels to generate electricity. In other words, this is San Miguel's public use. And so I think on these facts and in this case, it's undeniably clear that San Miguel's purpose is a public purpose to generate rural electrification for South Texas. Yes, Your Honor.
What's the best authority you have for your proposition that anything you have to do to mine lignite for rural electrification is a public use? I've not read any authority that really defines it quite so broadly, so I'm curious what you're relying on. Thank you.
Yes, Your Honor. I think you're right in that the universe is somewhat limited. You heard counsel for DCP mention the Canyon case, which we obviously have to read and take into account. You also heard about the Snellen case. And I think the Snellen case is how I would answer Your Honor's question. That's the one where there was a street and they wanted to condemn a portion of the center of the Grand Boulevard down there in Pearland, south of Houston, in order to build a fire station. And in that case, they were looking at what's been done in the 50 years. And they say, look, only one side of this corridor has ever been shelled or used as a street. And I think this is important because they say after 50 years, no steps had been taken to create an esplanade. So they're looking at no steps have been taken. That is the polar opposite of the situation here, where the steps that have been taken involve hundreds of thousands of dollars and decades of prep for this. To give some context to this, a lignite lease is not the same as an oil and gas lease. The amount of preparation that must go into mining for lignite, actually excavating it from the earth, is substantial. And this was in the record. And we put in the affidavit of Mr. Kazin. He talked about what was required. He said, look, since the 1970s, we have expended hundreds of thousands of dollars on environmental studies, archaeological studies, anthropological studies, aerial studies, floodplain surveys. We've drilled dozens of holes. We've extracted cores all around the Wheeler tract. That preparatory work that had to be put in place was crucial. They had to construct a highway overpass in order to prepare to mine this tract. The excavation equipment is unimaginably large and it costs millions of dollars. So the prep work has been going on certainly since the 1970s and even before. Yes, Your Honor.
You've got about 9 minutes left, but I did want you to address a couple of other issues, particularly the mootness issue that you've raised in your briefing. According to your position, the condemnation counterclaim urged by DCP is moot because the pipeline which formed the basis of its counterclaim has been relocated, and they are no longer seeking to use the land covered by its easement. Replied to their response, which argues that it's not moot because they've incurred multi-million-dollar damages, and to the extent you can also, at what point does a party show its intent to appeal, and the effect it would have in this case in the filings made by DCP.
Yes, Your Honor. I think it was Justice Watkins who mentioned about, well, the only available remedy here was specific performance. Not how it works, and she's absolutely correct. On the mootness point, it is not the trial court's ruling that has caused damages, to somebody in this case. What has happened is when DCP sought to supersede the judgment, and San Miguel utilized the Texas rules and superseded that, and that allowed the judgment to be enforceable and the pipeline to ultimately move to be moved. That mooted the condemnation counterclaim. Of course it did. The pipeline's no longer there. They don't want to, they don't remedy. What we argue on the mootness doctrine, on the mootness point, is that that's the ruling that they had to appeal, and they never did. They never did, not by separate appeal, not by a motion to this court in this appeal. They have not appealed that ruling on the supersedious bond. And they would have had to do that and make some argument about, well, that's improper because it cuts off our right to appeal. Our only claim is condemnation. And if we move the pipeline, that's moot. And they didn't make those arguments. And so that's our argument on the mootness, that failure to appeal the actual ruling that they're claiming has resulted in damages, that it's gone. It's a moot issue now. Your Honors, moving on to the second issue regarding whether a declaratory judgment action was proper, or whether this, yes, Your Honor.
I'm so sorry to interrupt you, Ms. Fry. I don't know if it just cut out for the rest of my colleagues, but the last maybe 15 seconds of what you were saying on your previous point, I missed. Could you please repeat that? And I'm so sorry to interrupt you with this, but I want to make sure that I fully understand the contours of your mootness argument.
Not a problem at all. On the mootness argument, the premise is that DCP was required to appeal the supersedious bond ruling, and that a failure to do that has rendered any claim on condemnation moot. The remedy for condemnation, for a wrongful condemnation, is to allow them to go condemn the property. DCP doesn't want to do that. They don't want to go move that pipeline back to where it was. And so to the extent they're saying, well, the supersedious bond is our damages and we ought to be able to collect on that, they didn't appeal that ruling. They didn't appeal it in this proceeding. They didn't file a separate motion in this proceeding, as you see is sometimes done in the case law. They simply didn't do it. And in our arguments are pages 33 through 36 of our brief, laying out that was the crucial ruling to appeal, and it just wasn't done.
Before Ms. Fry, before you move on to the next issue, I'd like for you to respond. Mr. Zabel indicated that the paramount importance doctrine in its entirety is a question of law. Do you agree that even the determination of whether the new enterprise will practically destroy or materially interfere with the public use is a question of law?
I do think it's a question of law. I think the trial court was correct on summary judgment to determine it as a question of law and to make that ruling. I think obviously that her ruling was correct and ought to be affirmed. When she's looking at material interference in this case, I want to correct the record here, because in the argument we heard a moment ago and in the briefs, DCP tries to throw out a lot of different numbers, and you hear 3.5% or 7%. The only number is 743,919 tons of lignite were sterilized out of approximately 5.89 million for a total percentage of 14.6. That's the only percentage. That is the percentage. The arguments about, well, somebody testified before the Railroad Commission. They weren't testifying about the amount of lignite sterilized by this pipeline. They were not. Yes, Your Honors.
So is the affected property Area G, all of Area G, the Wheeler tract, or are we talking about just that portion of the tract that surveys had been done and all those steps had been taken to determine that that was mineable?
Yes, the area that we're talking about is Area G. It is not some other tract. It is that this pipeline does not lay on or is not covered by the Wheeler tract. Area G, and you'll see this in the record in the trial court briefing, both sides only ever talked about Area G. In fact, the only place that I've seen this, well, maybe it's F and G and H, is only in the appellate briefing. The trial court briefing, that everybody's talking about Area G. Our expert used Area G, their expert used Area G. The pipeline is in G, and G has always been the barometer even for DCP. And when you talk about, the overlap of the Wheeler tract is not synonymous with Area G, but it's important to know that's the pipeline is on the Wheeler tract and it's in Area G, and that's the land that we ought to be looking at. And the percentage is 14.6%. In addition, the amount of money that was testified to, if the pipeline had stayed in place, the amount of money that San Miguel would have had to incur was 14.2 million. It is over 700,000 tons of lignite and $14.2 million material. It is to a nonprofit like San Miguel, when this is their only feed. This is the only lignite that they get, and it is the only lignite their plant is designed to use. It was material interference to sterilize that lignite. And by sterilize, I know it's kind of a strange term, but when you put the pipeline through, it's not just the pipeline itself. It sterilizes an area on both sides significantly, because you can't dig near a pipeline, or if you hit it, you'll blow up the county. And so we have these parameters on either side of the pipeline. So the amount of lignite that was sterilized, 14.6% on this Area G, was absolutely material. If nothing else, 14.2 million was certainly material to this nonprofit that relies on this feed. And when you take away this large amount of lignite from it, it increases the costs on all the rest of the lignite, because it is extremely expensive to mine for this lignite. Your Honors, my time is running short.
I'm gonna allot you a couple of a little bit additional time. I believe Justice Watkins had a question for you.
Yes, Your Honor.
I did, thank you. So I understand your argument that $14.2 million is material to, a nonprofit like San Miguel. But what authority do you have for framing the question that way? I thought that the question that we looked at had to be whether it practically destroyed or substantially interfered the use, not the cost, but the use. Thank you.
Thank you. So we think that, both the 14.6% and the amount of money, so the tonnage and the amount, are independently sufficient. So it's sufficient to say 14.6% of these minerals sterilized, that's materially interference. But as to the cost, looking at this as how does this materially interfere with the use? The cost to this nonprofit, we think, is part of that use. It's part of when you make them incur that amount and make all the rest of their lignite more expensive to mine, that you are impacting their use. And so that's where we're going with the amount of money. But to be clear, we think that the sterilization of 14.6% on its own, that was material interference with this public use. On the Railroad Commission, I just wanted to say that testimony is very misleading in DCP's brief. On the Railroad Commission testimony, Mr. Burris was not talking about sterilization of lignite. He was not. And so that number is just absolutely irrelevant. I don't want to go over my time, Justice Martinez, as far as.
Yes, just go ahead and make your final remarks, please.
Okay, thank you. Your Honor, the final remark on the trespass to try title versus declaratory judgment. This was properly brought as a declaratory judgment action seeking to invalidate a non-possessory interest. And we think that those cases are clear and cited in our brief. And finally, on this lease invalidation, where they're trying to invalidate our lease, San Miguel stands on the argument that DCP lacks standing to challenge our lease. And moreover, this idea that landowners like the Wheelers could just grant all the pipeline easements they want across our lease is an absurd reading. And so for all those reasons, we would ask that you would affirm the judgment of the trial court. Thank you.
Thank you, counsel. Mr. Zabel, I'll give you a couple of minutes extra should you need it, but we'll hear from you. Thank you.
Very much. So I'm just going to kind of take it in the order that counsel argued it. On the paramount public use doctrine, counsel indicated that we never proved that our pipeline was of paramount importance to lignite mining. We didn't have to because she never satisfied the three burdens she had to do, which is public use, existing public use, and substantial interference. It only shifts to us to show we're paramount if she satisfies or if San Miguel satisfied those three elements. So we never had a burden to show that we were of paramount importance. Counsel talks about how it's so easy to prove public use. I don't know whether the court, the most recent pronunciation on that is the Denbury versus Texas Rice cases that went to the Supreme Court twice. The courts have much scrutiny now on public use. It may have been easy in the past, but it's not easy anymore. And I think the courts are taking a very close look at what's public use and condemnation. And again, we talked about it as a two-step in our briefing. San Miguel trying to jump from generating and transmitting electricity to mining. You just can't make that two-step work because mining is absolutely not a public use and there's no condemnation authority for it. Counsel also indicates that it's not essential that you have the power of eminent domain. Every single case in Texas that we found that involves the paramount public use doctrine involves two parties that have the power of eminent domain. I challenge counsel or San Miguel to cite a single case where that doctrine has been applied where someone did not have the power of eminent domain. I don't think it exists because Texas follows the common law. All this other case law that we cited, it's the same doctrine, whether you call it the paramount public importance or the paramount public use, it's the same thing. It all derives back to the common law way back into the 1800s. It's all the same. So there's not two different tests, and they definitely have to have the power of eminent domain, which they don't have because they're not a public use.
Counsel, if I may ask, what relief is provided in this case, in this private condemnation proceeding? What relief specifically?
What relief in the private condemnation proceeding? We would basically, so in a case like this, there's the traditional condemnation where you negotiate and file your condemnation for an easement. And then there's another condemnation procedure called the cross bill, where if someone sues you for trespass or interference, you can immediately file an alternative cross bill for condemnation and condemn your pipeline in place. And the legislature passed that way back in 1895 because the railroads used to just build railroads without ever condemning, and they'd get sued for trespass. And the legislature, because they wanted rails, they let them immediately file for condemnation when they got sued for trespass. And that statute's carried forward all the way since 1895. So we would get an easement and our pipeline in place, and we'd have to pay them compensation for whatever damage we caused to them, which they chose not to pursue. If they wanted to come pursue us for $12 million back in the day, I mean, we would have fought it. I think it's inappropriate because I think the lignite really has little value to anybody other than them, but they sure could have done it. But they chose to put their eggs in the basket of paramount public use and not let us condemn.
So to address that point specifically, when San Miguel says that you're, to the extent, what supports your assertion that the enforcement of your supersedious judgment does not moot your appeal?
Sure. Yes, I'll jump right to that because I was going to cover that. So the way that the superseding is set up is we have a right to supersede. We have an absolute right to supersede, subject to them superseding our superseding. And if they do that, that is security for us on appeal if they're wrong. That is why that is in place. That's what it's there for. We don't think Judge Bauer abused her discretion in superseding our superseding. As long as they posted adequate security so that we could go up on appeal, and if we showed them to be wrong, we could recover against their security. It's not like those document cases that counsel cites where, you know, they went up on mandamus because they were going to have to produce the documents in the interim and it mooted the whole thing. We don't have a situation like that. We're happy with the security they posted because we made sure we had a hearing and established it high enough so that we could draw against it to recover all our damages. Did we want to move our pipeline? No. Oh, and here's the other thing. The one case that they cite, there's a Supreme Court case where they paid the judgment and they claimed that they waived it, but they wanted to avoid post-judgment interest on $24 million. Here's what happened if we didn't, when they superseded us, we basically had to move the pipeline and we suffered $14,000 a day in liquidated damages. And we might have to shut our entire pipeline down. This pipeline transports 20% of all natural gas liquids from the Permian Basin. That would be catastrophic, not only to us, but to every customer that we serve. So we couldn't put ourselves in that position. So we made sure we had adequate security to go against them if they were wrong in what the rulings they got in stopping our condemnation. So
And what more do you need to do other than file a notice of appeal and supersede, supersede the judgment in the separate matter to show your intent to appeal? Anything more?
No, I don't think so. No.
Okay. Mr. Zabel, it seems to me that Ms. Fry has said that you should have appealed the judge's decision in allowing them to post security to enforce the judgment, because then you could have had a ruling from a higher court, from the appellate court, as to whether you needed to move the pipeline or not. But my question really goes to where you stand today, or where the parties stand today, that if Ms. Fry is right, that your case is moot, your condemnation claim, then doesn't the trial court's ruling go without judicial review? And so we would be precluded from even saying, Judge, you were right or you were wrong. And what would be the point of a bond or any security?
Exactly. I mean, Judge Bauer, when you read the record, she struggled with this. I mean, it was them. She thought that it was best because, basically having us move the pipeline and giving us security, because that's what San Miguel wanted. They didn't want us to go up and just appeal the issues and not mind where our pipeline was. So Judge Bauer treated that very carefully and said, all right, San Miguel, you're going to make them move this pipeline. You're going to post security. And when they didn't post security, they were dragging their feet and posting it. She got mad. And she said, don't take a powder on this while they're spending this money. We had I think 3 months to move that pipeline, and they took 2 months to get the bond in place. We had spent $3 or $4 million totally at risk because they hadn't posted their bonds yet. And Judge Bauer really gave them a hard time when they got to the hearing and said, you caused them to delay getting that pipeline moved, so I'm not giving you your $13,000 a day, and get the bond there. So Judge Bauer fully expected that we would be able to recover against that security if we prevailed on appeal. So I'm just surprised this whole mootness issue has come up. As far as did I answer your question? I don't mean to. Thank you.
You did.
Thank you, counsel. If I may, you've got a few minutes left, but I did want you to address the issue of whether DCP's pipeline practically destroyed or otherwise materially interfered with San Miguel's operations.
Right. I found it intriguing as I was listening that counsel was talking about this $12 million in cost. It's called the Paramount Public Use Doctrine. I mean, it goes to use. And I know one of the justices asked that very question. It's the use that has to be interfered with, not some cost deal they may come up with on, what they may spend. And let's just say it's 14.6%. I don't think it is. I think it's 3%, but 14.6% is not substantial destruction. It doesn't even come close to substantial destruction. And if you were to look at Clerk's Record 4, pages 193 to 195, when they applied for their 2014 permit, 2 of the mining areas were on the Wheeler Ranch. There was area G and H, and there was an area F that was off their ranch to the north. Almost all of the lignite that they were going to mine out of this 9.7 million was on areas G and H. Area H, we don't even affect. Half of the lignite to be mined on the Wheeler property in area, all the lignite in area H, we don't even affect with our pipeline. We only affect a very small piece of area G. We were just on the south part of area G. So, I mean, if you look at the whole property, which is what the Canyon case says, 14.6% is no way you get to substantial interference or practical destruction. And they're not even affected on their other area, which is half the Wheeler property. As far as the standing issue, I think that's just kind of a red herring. We're saying they didn't satisfy their burden to show superior title. We don't have to show a thing. In a trespass to try title case is what they had. If they don't meet their burden, we don't have to do a thing. They lose. So there's not a standing issue there.
So the question about the validity of the lease was presented in yesterday's oral argument. If the panel yesterday concludes that the lease is valid, aren't we stuck with that? I mean, isn't that the answer that we have to accept? Thank you.
I'm glad you asked me that question, because that was kind of something that really kind of, I guess I had a really hard time with. So the Wheeler case went before ours. They had different allegations of lease termination, and the Wheelers actually sued San Miguel. So it was their burden to show the lease terminated. San Miguel sued us claiming a superior title. They had to show their lease was good, a prima facie case to beat us. So no, and we are not bound by the Wheeler case. We weren't a party. And here's what happened. When I went in to argue this in our case, and I like Judge Bauer, and I'm not trying to say anything negative about Judge Bauer, but she had already decided in the Wheeler case the lease was good. So when I came in and I started arguing, saying that's not binding on me because we're not a party to that, and we have different arguments, and they're the plaintiff in our case, they got to prove it. She said, move on to your other issues. I'm done with that issue. So we never really got to argue that. And actually in the Wheeler case, Judge Bauer found that the statute of limitations precluded her 248 ruling, Rule 248, which is a lot in the argument yesterday, that the statute of limitations precluded the Wheelers from asserting lease termination prior to 1978 when San Miguel originally got the lignite lease by assignment. The cases that even San Miguel relies on, when you prove up a lignite lease, you got to prove them all the way back to inception, back to 1954, and limitations never applies to lease termination. So we would have had all those arguments. We didn't get to make them. But with all due respect to Judge Bauer, we are where we are, but we would say that's not binding on us, and it has no significance in our case. So you could actually have, you're not going to say in our case the lease was valid or invalid. You're going to say they didn't meet their burden, their prima facie burden to show that they had a superior lease, and they lose on trespass to try title. It won't be inconsistent because it won't be an adjudication whether the lease was good or not. They just didn't prove that prima facie case it was.
Thank you, counsel. You've used your extra 2 minutes as well. Thank you very much to counsel. Your case is submitted and the court will stand in recess. We're adjourned.
Thank you.
Thank you. Have a good day.